to Getting on Board Trustee Learning Programme. Today's session is about property, and we've got Clare and Sam here from Russell-Cooke Solicitors. I've seen the slides. It looks like a really, really interesting session. So welcome. I'm Penny and I'm from Getting on Board, and I'm just going to take you through a few bits of housekeeping. So let me just share my housekeeping slide. So you will have seen that the session is being recorded. You will be sent the Zoom recording afterwards. That recording will have the chat on it if you send any messages to the group. So please just be aware of that. If you're asking a question you might want to change any sensitive details. The recording will also eventually be on YouTube, and that recording doesn't include the chat. You'll also be sent a copy of Clare and Sam's slides as well. As you've come in, you've been muted. Please stay muted unless you are called to ask a question. That's just so that everybody can hear nice and clearly. Closed captions have been enabled at our end. So if you want to have subtitles, you need to enable that at your end with the CC or closed caption button on your own device. Please feel free to use the chat. We'd really love to hear why you've come today, what you're hoping to get out of this session. And if you've got any questions, please do feel free to put them in the chat. And then finally, a really huge thank you to Russell-Cooke Solicitors. They've sponsored this session and they sponsored the whole strand in the Trustee Learning Programme, which means that we can offer it free of charge, which is very important to us. And of course, today they've also lent us Clare and Sam, who've planned this session for you, and they've come here to share their expertise. So we're really very, very grateful. So thank you. And I'm going to pass over now to Clare while I share her slides.
Great, thank you. Thanks for coming, everyone, to this talk on charity property trends and conundrums. I'm Clare Garbett. I'm a senior associate at Russell-Cooke, specialising in property law for charities, and my colleague Sam is an associate also specialising in the same area. We're part of Russell-Cooke's dedicated charity and social business team, so as well as advising on charity property, there are also lawyers advising on governance, commercial, fundraising, data protection and employment. Anyway, without further ado, if we could go on to the next slide. So there's sort of the bullet points that you were promised for this talk. It did a range of things. They were talking about sort of the background strategy and the specifics. So I'm going to talk about the background strategy, and then Sam's going to talk about specifics. So a word about the current climate. Obviously, we're not surveyors. This is more their remit than ours. And also, it's very difficult to predict what may happen next. So I'm just really covering some things that probably most of us already know about as a bit of background. But yes, working from home it appears to be something that is staying to a certain degree. In a lot of sectors, people are back to work around about 3 days a week, but there is more flexibility than there used to be. And in the charity sector, it seems that people are working from home more than in other sectors. But anyway, the effect of that generally in the marketplace is that the offices that are going to command the rents that people would like to see for them are going to be of very high specification, the kind of offices that people want to commute into, and that are very, a Cat A specification of very good quality space, which means, of course, that actually if you are happy not to have that, it can be a bit of a buyer's market for office space at the moment, in the sense that you might be able to get a better deal on something that's less high spec. So that's something to bear in mind. I think everyone is aware of inflation and the increases in interest rates, and that's having an effect on people selling and buying both commercial and residential property. So I'd suggest it's probably not actually a particularly good time to sell unless there's a pressing need to do so. And I've mentioned that residential rents continue to be high. So one of the things we were going to consider is the effect of this on charities specifically. I think these are trends that affect everyone equally. But when it comes to charities, I think there are two completely divergent ways they can go. So I mentioned earlier that some charities really are not in the office in the way that they were. And for those charities, they have one set of options. So those who genuinely feel they're not going to be using their office space or other space as much. Some of them have chosen to share space, this being a sector that specialises in collaboration. Some have chosen to sublet part of their space to gain an income. Some charities with freehold property have chosen to sell, either to take the money to invest elsewhere, or to lease back a smaller part of their original premises, or to go somewhere smaller, renting somewhere smaller. And some with leasehold property have chosen to end their lease either by exercising a break clause, which Sam will come on to, or a surrendering or assigning, meaning transferring their lease to another party, again, either to dispense with their office altogether or to move somewhere smaller. However, that isn't the only response. Of course, if you're a charity who needs to be in a property, then as I mentioned before, this might be a good time. Well, it's certainly more of a buyer's than a seller's market, I would say, not being a surveyor. So some of our clients we've seen taking advantage of a depressed sale market to buy property, particularly where it's strategically important to them. So, for example, neighbouring property that they might need for some particular operational reason, or taking advantage of a depressed commercial rental market to get a good deal on office or other space needed for their operations, or doing up their own commercial space to a high spec in order to take advantage of that tenant who will pay more for a really decent space. So I think those are the main responses to the current climate by charities. Then if we go on to the next slide, in terms of making decisions generally, because this is one of the points we were to cover, I've put on the slide the general duties that charity trustees have in all circumstances, and I've highlighted the particular ones relevant here, namely managing your charity's resources responsibly and acting with reasonable care and skill. When it comes to acting with reasonable care and skill, that includes taking advice where necessary, or if you have specialist knowledge, bringing that to the table. And when it comes to managing your charity's resources responsibly, you need to know what property you have and on what terms it is held. Generally, your duty is to do whatever will further your charitable objectives now and in the future. So when you make these decisions about, for example, whether to keep a property or to dispose of it or leave it, you need to think about the longer term as well as the short term. Obviously, you know, if you really are a charity who is never going to need its premises again, then it might well be a good idea to sell it, take the cash and use it, you know, invest it for the benefit of the charity. But you do also have to bear in mind that things might change in the future. And once you've sold a property, it's gone and you don't have the opportunity to make money from it or operate from it again. Yes, so and generally the thing you need to do is just take a reasoned decision, taking into account all of the relevant factors and minute it carefully so that when people come to look at the decision in the future, it's clear on what basis you decided to proceed. If we go on to the next slide. So going down to specifics a bit more on both acquisitions and then disposals. Oh, sorry, back one slide, thanks. So on acquisitions, there aren't any specific statutory requirements that you need to go through in the same way that there are for disposals, which I'll come on to in the next slide. But for acquisitions, you still are bound by the general duties that were mentioned on the previous slide. So you need to make sure that any property you're buying or renting is suitable for your purposes and any intended use, obtain any necessary planning permission, ensure that the rent or price paid is a fair one, ensure that you can afford the purchase, including any, if you are taking a mortgage to buy property, that you can afford any of the mortgage terms, understanding what obligations you're subject to under a lease, which is something that Sam will come on to, and checking that the terms of any lease are fair and reasonable, and again, taking appropriate professional advice. For freehold and long leasehold purchases, the Charity Commission recommends that the trustees obtain a report from a designated advisor, which I'll come on to, on evaluation of the land, advice on the price that trustees ought to offer to pay, or the maximum bid they should make at auction, details of any planning permission that might be needed, and details of any repairs or alterations that might be necessary, things along those lines. That's not just a statutory requirement. You do it strong where you're purchasing a significant asset like a freehold or a long lease. So yes, so it's not a strict requirement. Again, also, if you want in principle to pay more than the open market for particular strategic reasons, then it is open for you to do so, as long as you minute why it was so important strategically to have this property such that you were willing to pay over the odds for it. When it comes to new leasehold properties, the duty there would just be your general duties. So, make sure that you've had a look at the market and compared the rent that you're going to be charged under this lease with the rents generally available for similar properties on the market. Check that there aren't any defects, either legal or physical, in what you're proposing to take on, and check that your liabilities under any lease are limited. Again, Sam will come on to that. But again, it would be open to you to pay more than the market rent if there was a particular strategic reason for doing so. Then if we go on to the next slide. So with disposals, there is a statutory regime that you have to follow. I've set out on this slide, and then in due course on the next slide, what you need to do. Basically, to avoid having to go to the Charity Commission for an order authorising a disposal, and except where you're disposing to a connected person, where you will always need a Charity Commission order. And except in some circumstances, for example, a lease of under 7 years where there's a lighter touch regime, you'll need to obtain a report from a designated advisor. And I've set out on the slide the people who count as being designated advisors. And their report will need to cover various things, which I'll set out on the next slide. And then, having reviewed the report, decide that you are satisfied that the proposed terms of the disposal are the best that can be reasonably obtained for the charity. Bear in mind that a disposal doesn't just mean a sale. It also covers, for example, in terms of getting out of your lease, which is what Sam's going to be talking about. It also covers, for example, surrendering your lease back to your landlord, or assigning, i.e. transferring your lease to another party. So that makes both of those options much more complicated than they might at first appear. However, it doesn't apply to exercising a break right under a lease, which is another of the things that Sam will be talking about. And that's another thing in favour of using a break clause rather than those other two options. There are various exemptions. Oh, sorry, actually, let's go on to the next slide so you can see what the report would need to cover. So that, yes, that's setting out what the report needs to cover and the statement that the advisor needs to put into the report. There are some exemptions from the need to do this. As I mentioned, there's a lighter touch regime for shorter lease disposals that are shorter leases. But also, if you are disposing to another charity or to a beneficiary or to an employee, each in certain specific circumstances, then you won't need to go through this regime. Also, if there's a statutory basis for the disposal, then again, there's an exemption that would apply, but generally this is what you'll need to do on any disposal. Also, bear in mind that on any disposal, there will be other things you need to consider, matters at a governance, title, planning, and other level, which may prevent or interfere with your disposal of the property. And part of your duty to manage your charity's resources responsibly is to be aware of what those restraints are, and to, take advice on the best strategy for disposing of your property in those circumstances. I think that's all from the headline level. So I'll hand over to Sam.
Thanks, Claire. And so, yeah, I mean, if you're looking to downsize or come out of a lease, the like Claire mentioned, the easiest way to do that would be by exercising a break clause. And so, in simple terms, a break clause is a contractual right in the lease for the tenant, or in some cases landlord, to terminate the lease upon notice. And there are a couple of things to bear in mind with this. I mean, the first thing, if you're looking to exercise break clause, just make sure there is actually a break clause in the lease, because this will be something that's negotiated at the start of the tenancy. The other thing is where there's a notice period. So, for example, if there's a 6-month notice period for exercising a break clause, this will usually be what's known as time of the essence. So, if there's 6 months prior notice required for exercising a break clause, if you serve notice after that, so for example, if you serve notice with 5 months before the break date, it will be the break notice will be invalid. So you need to be very careful with making sure you know the notice periods required in service of a break clause. The other thing to bear in mind is sometimes in leases, in order to exercise a break clause, there are conditions attached to this. So usually the conditions will just be that at the time of the break date, the tenant must have paid all their rent, so there can't be any arrears, and the property is vacant with no sub-licenses or other occupiers in the property. So those are fine, and they're easy to comply with. But sometimes in leases there will be quite onerous conditions, such as a covenant or a covenant to comply with all the covenants in the lease. And so a landlord can always find some clause that you've in some way breached under a lease. And so this is very problematic for a break clause, because at the time of the break date, they can just go through the lease and find something which they disagree with, and then they could say, well, the break notice is invalid. So if you're negotiating a lease and you see something like that, you should always ask for it to be removed. The other one, which is a bit more common, is a condition to comply with the repair covenant in the lease. And so again, this should be resisted if you're a tenant, because it's very hard to prove that you've completely complied with a repair covenant under a lease. I mean, it could be that at the time of the break date, the landlord sends a surveyor around and they find some scuffs on the wall or something and say, oh yeah, this is a breach of the repair covenant, and so the break notice is invalid. And so again, if you're negotiating a lease, or if you've got a lease, just make sure that you're complying with all of these conditions. If you do have a condition like a repair covenant to comply with repair, then you can try and negotiate with the landlord to waive that if you sort of preempt it and agree with the landlord beforehand what repairs need to be done or don't need to be done. If they won't do that, then you're going to have to just do the best job you can at making sure that there's no disrepair at the time of the break date. Somewhat related to that is, at the end of a tenancy, usually what will happen is a landlord will send a surveyor around to compile a schedule of dilapidations. And this can happen if you terminate a lease by way of a break clause or at the end of the contractual term. And so you probably just need to accept that most landlords do this, and so there will be some costs for dilapidations at the end of a tenancy. And so by dilapidations, we mean disrepair at the property. And so There are ways of mitigating this and kind of limiting your liability at the end of a tenancy to make sure you don't get a huge bill for disrepair. And so the best way of dealing with this is to include a photographic schedule of condition in the lease at the start of the tenancy. And so any repair liability that you have is limited to whatever is shown in that photographic schedule of condition. So you won't need to put the property into a better state of repair condition than what's shown in the schedule of condition. And the other thing is, if you do end up receiving a bill for dilapidations from a landlord at the end of a tenancy, if it's quite a high cost, we'd recommend appointing a surveyor to have a look at this. And because surveyors can normally bring the level of cost down quite significantly, because the dilapidations cost should really be capped to whatever is the loss in value to the landlord. So if there's minimal dilapidations and disrepair, then it's not fair that the landlord is imposing such high costs on you, where they can still reasonably speaking let out that property to a third party. And so if you do get in that situation, a surveyor is a good option to try and bring those costs down if there is any sort of dispute. If you don't have a break clause in a lease and you want to terminate it early or get out of the lease, as Claire mentioned previously, there are sort of various other options which usually will be a right, a contractual right in the lease. So the first way of doing this is checking to see if you have a right to assign the lease. And assignment means that you can transfer the lease to a third party. And so in order to do this, you'll need to get the landlord's consent, and usually they can't unreasonably withhold or delay their consent, but you'll probably have to pay some costs for them to check check who the new tenant will be. The only one of the issues with assignments is that the landlord will normally want the charity to guarantee the obligations of the incoming tenant. So, for example, if the tenant doesn't pay rent, the landlord could pursue the charity for that debt of that non-payment of rent. So charities just need to make sure that they actually in their articles of association or trust can actually provide such guarantees. The other alternative is subletting, and so this is where a tenant, a subtenant can come in and occupy perhaps parts or all of the premises that you occupy under the lease. And again, you'll need to get landlord consent for this and pay some costs for the consent. But this could be an option if you can't assign the lease. The only thing you need to bear in mind here as well is that there are some risks. So you essentially become the landlord, and so you have to be dealing with the collection of rent and so on. And then if there's a problem with the tenant, it will be your responsibility to kind of sort out those problems. So if at the end of the tenancy the tenant is refusing to move out, the landlord can make a claim against you for not being able to provide vacant possession at the end of the tenancy. Another method is licensing or sharing spaces. So this is quite an attractive option for charities. as Claire mentioned earlier, assignments and subletting, they are considered disposals. And so you need to comply with the Charities Act requirements on disposals when assigning or subletting. Licensing is exempt from that. So that's one thing you don't have to deal with when you're licensing or sharing. You most likely you will need to get the consent of a landlord to do so. But it's a very flexible regime, and you can have quite a simple agreement with perhaps another charity or a small company to kind of share spaces or even let out desk space as well. The important thing to remember with a license is that you cannot give exclusive possession to a licensee. So if, for example, you grant a license to a tenant and they occupy one part of the office exclusively, this is actually more like a sublease than a license. And if you've granted a sublease rather than license, it's possible that you've inadvertently given them some rights of occupation, and they actually have a protected tenancy. So what you need to bear in mind with sharing is it should truly be a sharing arrangement where both parties, the landlord and the tenant, they're occupying the same space together, such as using desk spaces and so on. And usually there'll be an ability to, if you need to move them to another part of the building, or if necessary. Okay, if we go to the next slide.
Can I just come in with a question, Sam and Claire? There's just been some conversation in the chat about how much of this is applicable beyond England. So how much of what you're talking about, what you're going to talk about, is applicable to Scotland and Wales?
I apologise, I've set a hair running.
That's fine. Well, the Charities Act disposal. So I saw there was another comment in the chat about the Charities Act disposal requirements. That's what I was talking about when I was talking about the valuation reports. That only applies in England and Wales. And I will confess I'm not aware of the relevant legislation on whether you have to go through a valuation procedure with respect to disposals in Scotland, but it does apply in England and Wales. The other points, I mean, the points we've made generally about leases, I think, are pretty relevant across the board. But as Susanna mentioned in the chat, I think there are slightly different points in relation to dilapidations, etc. I hope that answered the question. Yeah.
Thank you.
Okay, so yeah, I mean, dilapidations are a sort of big concern at the end of a tenancy, and so one way of limiting that liability is to make sure that your tenancy is an internal only repair. So usually this will be because the property is defined in the lease as the internal parts of the building alone. And the reason that it's much better to have an internal only repair is that the most expensive items of repair are usually the structural parts of a building, like the roof or the exterior of the building or the foundations of the building. And so if you have a full repair liability of a whole building, then the landlord may require that you carry out repairs to the roof, for example, if they, at the end of the tenancy, send a surveyor who discovers that there's some issues with the roof. So an internal only repair liability is something to look out for in a lease. And again, even with an internal only repair liability, we still recommend that you get a photographic schedule of condition with proper descriptions of the state of repair and condition of the internal parts of the property, because again, this will be your main bargaining tool when you receive a claim for dilapidation, or if you receive a claim for dilapidations at the end of a tenancy. We also recommend that if you do have an internal only repair lease, it's very likely that there will be some sort of service charge, because the landlord will want to be reimbursed for any costs that they incur in maintaining the exterior of the building or the common parts of the building. And so there will be a service charge, and if there's multiple tenants in a building, the tenant will most likely pay a fair proportion of those costs in the building. You need to bear in mind the risks with the service charge. So when you're negotiating a lease, the service charge there will probably be a service charge budget at the time of the new lease, which is provided to you. But this is just an estimate given by the landlord, and it might not take into account in future there could be major works on the building, such as repairs to the roof, scaffolding needing to be put up, and so on. And so in future, it's possible that, at the time of the lease, there's an estimated service charge of £10,000 a year. But if there's major works in the future, you as the tenant, you'll just be recharged a proportion of whatever costs the landlord has incurred. And so it may be that you only have a 5-year lease, and in the 4th year of the lease, the landlord does major works to the building, and suddenly the service charge goes up from £10,000 a year to £50,000 a year. And so we always recommend that you try and negotiate a service charge cap when you're taking on a new lease. And that would mean, it doesn't mean you're going to pay the service charge cap every year, but if there were major works and the costs go up to a really high level, you know for sure that I will only ever have to pay X amount in any given year of the lease. And if you can't negotiate a service charge cap, again, we'd recommend that you do your own due diligence, get a surveyor to go around and check the state and condition of the building, because if it looks like the building is in a very bad condition, then it's likely that there will be kind of big costs. So you might need to take a view on whether it's worth the risk, or you can raise those issues with the landlord and see if those can be remedied before the lease is entered into. The other thing to bear in mind with leases is, with taking on a new lease, is landlords often waive the VAT exemption on commercial buildings, and they choose to charge VAT on the rent. And so if you're VAT registered and you're able to claim back VAT, this shouldn't be a problem for charities. But if you're not able to do that, then it's a 20% uplift in the cost of the rent. And so you need to check that whether or not the landlord is charging VAT on rent, and if you're able to claim back those costs. And as a final point, when you're negotiating a lease, as Claire said, it's sort of it seems like a buyer's market at the moment. And so there are various statutory requirements that a landlord should deal with, such as they need to provide you with an EPC. They should provide you with certificates in respect of asbestos, a fire risk assessment for the building, an EICR for electric installations, and so on. But once the lease has completed, these responsibilities will normally be passed on to the tenant. And so when you're negotiating a lease, you should always make sure that the landlord provides you with all of these compliance certificates before you complete the lease. And if they don't have them, you do have quite a strong bargaining position to get them to carry out these checks. And if they if they fail the checks, then you can ask the landlord to remedy those issues before the lease is completed. And in particular with EPCs, it is a legal requirement for a landlord to provide an EPC, which is an energy performance certificate at the start of the tenancy. Under the current regime, the rules are that in order to legally let out a building, you need to have at least a grade E on the EPC certificate, and it seems that the government may increase the minimum energy efficient rating in the coming years, and so if the government do this, the landlord may need to carry out various energy improvements, energy performance improvements in the building. And so you need to make sure in the lease they're not trying to pass these costs on to the tenant. So either via the service charge or just an explicit clause in the lease. And so, yeah, just make sure that you try and gather as much compliance certificates from the landlord as possible before you enter into the tenancy. I mean, another problem is if you don't do this, you can get into the building and realize the electrics don't work, but at that point it will be your responsibility to carry out all those repairs. It won't be the landlord's responsibility at that point. So because it's a buyer's market, you can essentially get the landlord to do all these repairs before the lease is completed. That's it.
Any questions? Feel free to come straight in and ask them. You don't have to do it in the chat.
We've had some in the chat, so shall we start with the chat ones?
Sure.
Some of them have come up direct, and it's fine if you want to send a direct question, do it via me if it's sensitive or you want to be anonymous. So we've got a question which says, I'm not sure you mentioned the need for a Charities Act valuation, which we have sought separately to the agent that is marketing our property. Are we in overkill?
You're not in overkill. That's what I was mentioning when I talked about the statutory requirements on disposals. So that's exactly what you are supposed to be doing. Yes.
Thank you. And a clarification here, an electrical and gas, if installed, safety certificate will also be required. Sam, did you want to come back on that?
Yeah, that's right. So you should be, if there's a gas supply at the building, you should be checking that the landlord's got a gas safety certificate. I mean, there's a whole array of compliance certificates that a landlord will need to provide. So it would take too long to go through every certificate that's required. But if there is a certificate required, you should ask the landlord to provide it before the tenancy. I mean, often they say, well, it's your responsibility. It's your responsibility. But if there's a problem, if the boiler doesn't work, they need to fix that before the tenancy commences, and so that would be disclosed in a gas safety certificate. So if you've got the gas safety certificate, you can see that.
Great, thank you. And Andy, coming to you for a question. You've got your hand up.
Yeah, thank you. I think it's been very interesting. I'm here as a chair of a charity that has rented out 98% of our 6,500 square foot building to the NHS, and we've just retained a little landlord's office. But so I found it very interesting. But I also have a little company that rents out very nondescript small shops on suburban high streets, and about average 800 square feet. And I would just like to encourage anybody on the call who's trying to rent out space that is relatively small, that go further than what you've heard on the webinar today, because it definitely is it's a buyer's market if you're trying to enter a lease rather than a seller's market. And I think that my peer landlords are really foolish because they don't do some of the really obvious things that have been mentioned today, like internal only repair is a no-brainer. Why would we expect a tenant that is either a small business or a charity and is looking carefully at income and expenditure to repair the outside of a building that they're potentially occupying for a small time, it's just obvious. Ask immediately for an internal only repair. Also, ask the potential landlord, how did they treat their tenants during COVID? And ask them for evidence. So in my small portfolio, anybody who was forced to close, I didn't charge them any rent because I thought this was a brilliant opportunity to show them what a good landlord I am. And hopefully when COVID had ended, they'll all stick around for 20 years. And I reckon they will. So I've had no void periods since. I've got really high level of allegiance from those tenants to the space that they're in. And it was a golden opportunity for landlords to show that they were different to the average player in the market. In terms of being the right sort of landlord, I think that you can tell when you go into a negotiation with a potential landlord really quickly the likelihood whether they're going to be supportive or not. And the landlord may not give away, but it's quite hard to find tenants at the moment, especially if you're not a decent landlord and don't engage properly, show up for face-to-face meetings during negotiation, etc. So I just want, the real reason I wanted to ask a question was to ask the panel to comment further on how they see the power dynamic between lessee and lessor now, say, compared to, you're all really young, but compared to 20 years ago.
I think it is a bit of a buyer's market at the moment, but I don't think there's really much else I'd add. I don't know, Sam, if there's anything you'd want to say on it.
Yeah, just anecdotally, it does seem to be a bit of a buyer's market, and so you do get some buildings that there's been empty units for a really long time, and so the landlords are desperate to get tenants in there. And so yeah, I agree, you should you should push really hard on on these things that we've mentioned, like a service charge cap, on internal only repair, on getting the compliance certificates. Just push the landlord to provide all these things, because it seems most likely in this market you will get it. So they'll probably say no, in the first instance. But if you push them, then I'd agree with that.
Yeah, sorry, can I come back with just one other feature which I meant to mention, and that is the break clauses. So I when I let little properties now, my break clause says it's 30 days notice at any time. Because why, as a landlord, would you want a tenant there who wasn't happy? Because probably they stop paying, they won't cooperate, they might go silent, they might go away with the keys. And then if you follow the rules, you have to apply to get access. You might not be able to get that access very easily. Down in the south of England, the local county court advises tenants who are being evicted not to cooperate. So it's just nonsense to imagine that trying to believe that you will get a good result from having very difficult break clauses as a landlord. It's nonsense. I recommend people's starting point in this in negotiation is start asking for a 30 days notice at any time.
I think you're very enlightened as a landlord, but unfortunately, often they aren't. They want to put you on the hook for something that's much more onerous just because they can, even though, as you quite rightly point out, the kind of commercially sensible thing to do is to give as much flexibility as possible. But yes, it's quite rare that we see a break clause that could be exercised at any time on 30 days notice. Usually the best you might get is a rolling break clause on 3 or 6 months notice. But it's nice to see you're doing something a bit more flexible than that.
Thank you. It's really interesting to hear it from the landlord's perspective, an enlightened landlord. We've got a question here about repairs to rental property, and I don't know, Claire, if you think there's enough information in the question, or if we need the questioner to come back with further information.
Well, yes, I think I saw her briefly on the screen earlier. But I mean, generally, I'm assuming, tell me if I'm wrong, that you are tenant. Is that right?
Yeah, we are tenants. Can you hear me?
Yes, I can hear you. Yep. So your tenant, and are you responsible for the interior or the structure of your property?
The interiors.
Okay, so you're trying to get repairs done to the interior or to the structure?
I think to interiors and some, modifications yeah.
Okay. Well, if it's the interior, then it would be your responsibility and the thing that you have control over. So in answer to your question, you can get anyone to come and do those repairs. If they're genuinely within what's your responsibility under the lease, then you don't have to select the landlord's contractor to do that or anything. It can be up to you, and you can go and select whoever you'd like, I would have thought. However, if it's something that's within the structure of the property, then unfortunately you have to sort of go to your landlord and say, I want this done, and then wait for the landlord to do it, and then possibly recharge it to you via a service charge. Does that answer the question, or was there more?
Yeah, it does to some extent. We are trying to get in touch for this places for people, like a repair company, which have worked for us previously, but now they're not responding, and we worry that currently that the lease will come to a point and the repairs and things are not being done. So we can get a private person in, according to you. Yeah. Okay. Yeah. Thank you.
No worries.
Thank you. A really interesting question here from someone who says, what are the rules around buying or leasing property from a trustee? So the charity doing that from one of their own trustees.
Okay, so there, it's a disposal to you rather than you disposing of land. So in terms of the statutory requirements on disposals that I was talking about earlier, none of that applies, because I think we are saying, right, that it's a trustee is renting land to the charity. Is that right? Yes. So really, it's more a question of your general duties and making sure that there's a proper arm's length commercial relationship between the parties. So making sure, all the things that Sam was talking about earlier in terms of making sure that you're transacting on the best terms reasonably obtainable for your charity. And that's always should be your focus. You're always acting in your own charity's best interest, however much you might like the other person or know them, etc. You've always got to be thinking about what it would look like later on if the Charity Commission was looking at it and said, oh, you haven't got proper commercial terms in place. Those are my thoughts on it. Does the questioner have any other follow-up question on it?
We'll ask them to say so if they do in the chat. And I guess that the trustee would need to be outside of any decision-making on that as well, wouldn't they? And in terms of conflict of interests. Yes, exactly. They'd need to be absent for any of those discussions and separately represented, etc. Yeah. Another question here. Somebody asked, what kind of strategic reasons are there for paying more than the market value for a property? So you might have a particular, so for example, I've got a client at the moment whose strategic objective seems to be buying all the properties around their religious centre. I'm not sure that that's necessarily the best strategic reason, because I think one of the properties they're taking on is a bit of a liability, but they've decided in that situation that they and their congregation, the thing they want is to have as much space in the area as possible. I have another client who is a museum and wants to expand next door, and so they got a valuation report, but they were also in principle willing to pay quite a lot because they wanted to secure this particular property. Sam, I don't know if you've got any thoughts on other strategic reasons.
I mean, it's not always about the cost of something. Like Claire said, it's a charity might have a charitable objective that they need to fulfill, and in order to do so, you have to pay above market value, for something. So in the surveyor's report, the surveyor will not be, you know, really thinking about these sort of things. And so the surveyor might say, actually, this is above market value. Is that in the best interest of the charity? And the charity can consider that advice and say, well, yes, we do think it's in the best interest of the charity because of this is in fulfillment of our charitable objectives. So it just needs to be a reasoned decision, and you need to have your eyes open and a proper paper trail that you've actually considered professional advice. But you know, there might be a charitable reason why you need a certain property, or you need to sell property at a certain time, which the surveyor might not agree with if they're just looking at it from a financial perspective.
And actually, that's something in your discussions with the surveyor at the start. If there's a particular reason why you do want this particular property, it's worth actually setting that out, and then they can frame their advice accordingly. I mean, they're obviously not going to sort of tell you something that's not correct, but they just will understand your strategy in the background. And in terms of, I mean, with charitable objectives, for example, you might have a property that you want to use for your beneficiaries that's particularly wonderful for that set of beneficiaries for a particular reason.
Could I volunteer a scenario that I've seen before is a charity that wants to be closer to stakeholders, so in the same building as stakeholders or donees or service users. So it's more about the people, whereas the surveyor will only look at the property to an extent.
Thank you. Really useful with the examples. Thank you. I think we've got time for one more question. And we've got a question which is, I think, around the professional advice, which Sam was just talking about. So when do you need a surveyor and when do you need a solicitor? So explain to us what the different, maybe there's other professionals we need to know. Who does what, for those of us that know absolutely nothing about property?
Sam, you can take that one if you like.
Yeah, sure. I mean, so generally, a surveyor will be brought in before we start negotiating the actual lease. So you might you might need to consult a surveyor in getting a deal for a property, because the surveyor has knowledge of the market. They have knowledge, their commercial knowledge, and so they're better at negotiating heads of terms as well and things like that, because they have a commercial knowledge. So it may be at the start of a transaction you get a surveyor, and then also in terms of particular issues with a building, structural points and things like that, you need to speak to a surveyor rather than a solicitor. So a solicitor, when you have the agreement in place to take a lease, we can put that agreement into legal terms and make sure the agreement is actually properly reflected, and to make sure the drafting is not heavily favouring the landlord or something like that, and also in terms of interpretation of certain clauses. But if it's really a commercial point, or something to do with the actual building itself, usually that's for the surveyor. Where it's to do with the lease and the interpretation of the lease, the drafting of the lease, that's for the solicitor. Thank
you. Now, one more question has snuck in, but it's going to need to be a quick answer. So tell me if you don't think you can do it. Joanna says, solar panels have been fitted to our property, but the social housing provider hasn't connected for us to get any benefit. Can you advise whether we can pursue this? And we're assuming this is on behalf of a charity, not a resident.
I'm not sure I feel qualified to answer that one. Do you, Sam?
I get it. Probably it depends on what you've agreed with the housing provider. So and again, it depends on what's contained in the lease itself. So it may be that if we were to look at the lease, this is something that has been agreed and that they're in breach of their obligations, but we'd have to look at it a bit further to know whether that they're actually in breach of something here.
Thank you, Sam. Useful pointer. Thank you so much. Thank you so much, Claire and Sam. It's been a really enlightening hour. Thank you to Russell-Cooke for enabling us to put this on free of charge. Yes, Jenny, thank you. Thank you for mentioning Land Aid. There's also the Ethical Property Foundation, isn't it, that provides some help here. So thank you all very much. I've posted the evaluation form in the chat. We'd love to hear what you thought of this programme, of this session. We also ask you in the form if you've got other suggestions for other things that you would find useful for you as trustees. That's how we source all of these free sessions. So if you've got ideas for other sessions, please do put them in the form. And then just really quickly to highlight getting on board, the fact that we have this enormous free trustee learning programme. I've put the link to our other sessions in the chat. Please do have a browse and come along, see if there's anything else that you would find helpful. We've also got free guides to becoming a trustee and to recruiting trustees on our website at gettingonboard.org. And we've got our Festival of Trusteeship coming up, which is the first week in November for Trustees Week. It's 2,500 trustees coming together for 23 events over 5 days, all online. Everything for aspiring trustees is free. Everything else is £5 a session or £25 for the week. If you're quick enough, you can get the early bird, which finishes on Friday for £20. So just a few plugs for other help available from Getting On Board. But thank you all very much for coming, and I hope you all have really lovely afternoons. Thank you.
Thank you.
Thank you.